Well, I think that I'm live now. So if I'm right, welcome. Welcome everyone for this employment law session. Hopefully some of you know what we're here to do. So I'll tell you in any event. My name is Lior Samfiru. I'm the employment lawyer. I'm one of the founding partners of Samfiru Tumarkin LLP. We operate in Ontario, in BC, and in Alberta. And what we do is we solve workplace problems. We do that when we practice law, but I also take this opportunity to come on here and answer your questions about workplace rights, about employment law, about your job, your rights. So if you have any questions, this is the time for you. This is the session for you. You have the opportunity to ask whatever the issue is about your workplace rights, whether your boss is mistreating you, whether your job has been lost, or maybe your job is in jeopardy. Maybe you've been put off work. Maybe it's a vaccine mandate question. Whatever the issue, there are rights, there are laws. We actually have amazing employment laws in this country, some of the best employment laws in the world. But the law can't help you unless you know what it is, unless you give it that opportunity. So that's why we're here, for you to ask your questions. So if you're watching me right now, what a great opportunity you have. You have one of the top employment lawyers in the country here, only here for the purpose of answering your question. Type it in, press return, I'll see it, I'll answer it, and you walk away with the information that you need to have. But let me give you some other contact information as well. So here I can answer questions. I can't actually get your rights. I can't, do something for you other than answer your questions. If I need, or if you want me to do something for you, it's easy to connect with me off air, off social media. All you do is you go to employmentlawyer.ca. You see that address below me, employmentlawyer.ca. It's the website that has all the contact information, phone number, email addresses, everything that you need to reach out to me is right there. So take advantage of that and make sure that you contact me if you have a workplace issue. Okay, we have a whole team across Canada, again, Ontario, BC, and Alberta, just dedicated to helping you in solving your workplace rights. But that's for later. Right now, we are live, okay? And we're live answering your questions. So if you want to know something about your workplace rights, take that opportunity. We have some time for you. Make sure you get that question in early, because sometimes at the end of the session, a lot of people try to get their questions and then the time runs out. So don't let that happen to you. So I'm going to start answering some questions right now. Again, my name is Lior Samfiru. I'm the employment lawyer, and you can contact me anytime at employmentlawyer.ca. All right, first question of the day, and thank you for that, from Jennifer on Facebook. I watched all accountability be written out of corporate policies and government laws. Okay, well, you're not asking any questions, so I can't help you there. Next question from M. Ellie on YouTube. Is there a cut of time for which one can seek severance or EI after being placed on an unpaid leave for refusing the vaccine as a long-term care employee? So the problem is, as a long-term care employee, there's a government mandate. Okay, so if you're being put on a leave because of a government mandate, there's nothing that you can do until the mandate goes away. If you're in a workplace where there's no government mandate, but your employer still decides to put you off work, and if you're not vaccinated, then you can choose to treat that as a termination of employment and pursue severance. You don't have to wait a day, a week, a month. You can simply look at the leave itself as a termination of your employment. So again, doesn't apply in Ontario, at least to long-term care employees, because we have a government mandate. But so the question always you want to ask yourself, is my employer doing this because the government is telling them that they have to? If the government's telling them they have to, there's a mandate, then there's not much you can do, because it's not your employer's decision. If the government is not telling them that they have to, but your employer chooses to do it anyway, then yes, you absolutely can do something about it. And one of the options is to treat it as a termination of employment. All right, continuing. I'm going to ask your questions, guys. Those joining us, my name is Lior Samfiru, the employment lawyer, here live answering your employment law questions. From Holly, next question on Facebook. Have you and your firm had any success in getting compensation or job back for people that were terminated as a result of vaccination policy? Any success for employees that were employed in healthcare? Absolutely, yes. We've had success across the board, across the country, in both getting compensation and, yes, even getting jobs back. in healthcare, in banking, and all other industries as well. So yes, we're absolutely been doing that and are doing that every single day. So if you're in that situation, it starts by us having a conversation. Starts with us understanding what your matter is about, why you were put on leave, and your job, etc. So because of that, if you want to have that conversation, whether it's you, Holly, or anyone else, easy, reach out to me through employmentlawyer.ca. Again, employmentlawyer.ca. But right now, I'm live answering your questions. I see a question here from Christine, who says her name is Steve. But in any event, Christine or Steve, that question is way too long. I can't read this here on air. So you'd have to make it at least 60-70% shorter for me to be able to properly address it here, or you just contact me off air at employmentlawyer.ca. So next question from Lori on YouTube. Can any termination clause be challenged, and should you always have a new employment contract be reviewed by a legal professional? So let's start with the second question. Absolutely. Anytime you're signing or about to sign an employment agreement, you have to have us review it. Whether you're accepting a job offer or you're already working and your employer's presenting you with a new employment agreement to sign, you have to, must have it reviewed. There are likely a lot of terms there that are problematic. Oftentimes employees are going to look at, well, what is the salary? What is the vacation? I get that. But there are terms there that could be a lot more problematic. Terms that limit your future severance. Terms that allow the company to change your job, your pay, your hours of work. Terms that allow the company to put you off on a temporary layoff whenever they want, and other terms as well. So as a general rule, you should never sign an employment agreement without having a chat first. Let us understand what it is and tell you what you need to be worried about, if anything. Now, in terms of termination clause, so termination clause is a term in an employment agreement that tries to limit your severance. Many of them are unenforceable for various reasons. So I'm going to say maybe 70% or so can be challenged as not being enforceable. But I need to see it. So just because you sign something that limits your severance doesn't mean that it's doing that properly, that it's effective in doing that. It may not, but I need to see it. I need to see that severance clause, the termination clause. And the difference, by the way, between having an enforceable termination clause and not having one can be the difference between getting 8 weeks severance and getting 24 months severance. So it's a huge deal, okay? So hopefully, Lori, that helps you understand the situation. Next question, though, right now from Kevin on Facebook. I have a slight disability that I feel is getting in the way of getting to work and leaving work. I have asked my employer if I can work from home, but got a negative response. I am not sure if I can do my work from home. Can I submit a doctor's note with an explanation? If my employer cannot accommodate, would my employer offer severance? So here's the thing. Your doctor is judge and jury. So if your doctor says you need to work from home, then your employer has to allow that if it's possible. Obviously, if you can do your job. Your employer your doctor doesn't need to say what the medical condition is. It doesn't matter. What matters is to say that for medical reasons, you need to work from home, whether it's every day or every other day. And if you can do your job, then they have to allow for that to happen. There's a duty to accommodate. If you can't work in the office and you cannot do your work from home, then your employer is allowed to say that this is what we call a frustration of contract. They would still have to pay you severance, but only a small amount. It would not be your full severance. It could be very small amount, okay? So that's important to understand, but you start with that doctor's note, and your employer has to accommodate. And again, maybe it's not every day. Maybe you don't have to work from home every day. It's just harder for you to come in every single day to the office. So maybe you work in the office a couple of days a week. You work from home a couple of days a week. So talk to your doctor, but that doctor's note is the most powerful tool that you can have. So hopefully that helps Kevin understand that situation. If you want to follow up with me, depending on your employer's response, you know what to do. If they refuse to accommodate, for example, employmentlawyer.ca. Again, employmentlawyer.ca to connect with me so we can get to work to actually help you if you need that help. For those joining us, first of all, welcome. Happy to have you here. Want to hear from you, want to get your questions answered. I'm Lior Samfiru. I'm the employment lawyer with Samfiru Tumarkin LLP, and I'm here answering your questions. I'm going to continue doing that, so please, you have some time still. Ask your questions. Don't wait till the last minute. Ask them right now. Okay, next question comes to us from Sunny on YouTube. Yes, I have been with my employer for 15 years and I receive an 8% vacation, which is 4 weeks per year. Currently, I have almost 12 weeks of vacation in total. I am planning to resign. However, my employer said that they would only pay the minimum required by the ESA, which is 2 to 3 weeks. Is that legal? So here's the question. The question is, would you have had the 12 weeks, to use now, or do you have to earn them during the course of the year? If they were available now to be taken, then they have to pay out the full amount, not just the minimum, okay? So they have to pay the full amount. If they don't pay you the full amount, you can contact me, or for that, you can actually go to the Ministry of Labor, okay, in the province where you work, and they can deal with that for you. You cannot go to the Ministry of Labor if you're let go. If you cannot go to the Ministry of Labor if you have a constructive dismissal, or if you're laid off because of a vaccine. You can go to the Ministry of Labor if you have an overtime issue or a vacation pay issue. So no, Sunny, it's not something that they can do. So if they don't pay you what you're owed, Ministry of Labor is probably the most efficient way to deal with that particular issue. Okay. All right. Next question. I think it's a follow-up or a second question from M. Ellie on YouTube. My employer initiated the vaccination mandate before the government made them. Would that affect my ability to seek severance? Potentially, you again, if you were put off work before the government said that they had to, then you potentially could get severance, assuming you're not a unionized employee. By the way, everything we talk about here only applies to non-union employees. If you're a unionized employee, that doesn't apply to you. None of this. You have to talk to your union about your rights, and the union is the only one that's allowed to help you. But yes, if you're not a unionized employee, MLE, and you were put off work before there was a government mandate, then yeah, you may still be able to pursue severance, and you should contact me as soon as possible, again, through employmentlawyer.ca. Okay. Christine or Steve on Facebook says, if I take an early retirement because of harassment, would my pension be affected if I were to file a legal course against the employer for lost wages, potential promotion due to a reprisal for the last 4 years? So the reality is that you're not going to be able to claim for lost wages if you can show that you're being harassed, and that's why you quit. Then you could claim for severance on a go-forward basis. And depending on how long you've been there, that could be as much as 2 years' pay. Now, for the severance period, whether it's 2 months or 6 months or 24 months, however long the severance period is for you, your employer is going to have to continue contributing to the pension plan. It's as if you were still working. So the value of the pension would be what it would have been at the end of the severance period. Okay? So no, you're not likely going to be able to claim for anything that you lost over the last 4 months or 4 years, but you can claim for severance. But you have to prove that your employer is harassing you. That your employer is not going to admit that. They're going to say you're not being honest. So how do we prove it? Are there emails, recordings, witnesses? Is there something to corroborate it? If there is, yeah, you can absolutely claim for severance, and we should talk about that as soon as possible. And again, for you, Steve, and you can contact me through employmentlawyer.ca. Again, employmentlawyer.ca to connect with me and my team. Phone number is there, email address is there. Everything you need to connect is right there. That's the place you go to. All right. So for those, again, joining us, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. And for the next 15 minutes or so, I'm going to continue doing what I've been doing, answering your questions live. So ask your question. Okay. Rocket asks, are the employment laws discussed here different in other parts of Canada like Quebec? Yeah. So everything we talk about only applies Ontario, BC, and Alberta. It doesn't apply anywhere else. Certainly not Quebec. Quebec has completely different laws. But no, anything we talk about only Ontario, BC, and Alberta, nowhere else in Canada. If you're outside of those 3 jurisdictions, you have to connect with a lawyer in one of those provinces and get advice there. But everything you hear today only applies to non-union employees and only in Ontario, BC, and Alberta. Okay, next question on Facebook from Kim. I've been working for my employer since August 2011. Got laid off November 4th, 2020, and haven't been called back. What can I do? Well, it's easy. You just contact us and we get to work to get you the compensation that you're owed. Obviously, that's not something that they're allowed to do. You are owed severance, so you need to contact us. Don't wait. That limitation period is going to expire before you know it. So, Kim, you need to contact us ASAP. Again, to do that, easy to do. We've said it before. I'll give it to you again. employmentlawyer.ca. Again, employmentlawyer.ca to connect with me and my team so we can get to work and deal with this workplace issue that you're having. Okay, thank you for that, Kim. The next question is from Jordan. How does sick pay work for a gig worker who may work for multiple employers in the same day? An example could be 2 or 3 shifts of 3 to 4 hours each day on the same day. Would that use 1 day of sick pay entitlements, or would that use 2 or 3 given that it's multiple employers? So you probably don't get sick days because your employer is not considering you likely to be an employee. They're considering you to be a contractor. So it's probably a moot point. If your company is offering you sick pay, you should talk to them about how they administer it. But chances are they're not going to provide that because, again, they don't look at you as an employee. And until there's a decision, which I'm working on, to have you classified as an employee, that's going to be a moot point. All right, next question from Steve Steven on YouTube. I have been fired after a fixed-term contract expired, i.e. my fixed-term contract finished February the 28th, and I was fired mid-March, 2022. Okay, got it. My boss gave me 2 options: finish mid-March, prorate pay for month, or work to the end of the month to get payment, but had to work to get paid. So here's the thing. If you had a contract that ended in February, but despite that, your employer kept you on without a new contract, you've now become a regular indefinite employee. Once that contract expires, but you're still kept on, the moment you continue beyond that date of the contract, you become a regular indefinite employee, which means if your employer lets you go, they owe you severance and that contract becomes irrelevant. So Stephen, depending on how long you've worked there, the type of job, your age, you could be owed anywhere from 3 months to 24 months of severance. So that's the issue here, not the options that they gave you. Forget about those options. It's a question of what they have to do, what they have to pay you. So Stephen, you got to really contact us as soon as possible, today even, and let's have that chat and figure out what you're owed, because yeah, it's good news if you're kept past the expiry of your contract. So make sure you do not sign anything and you contact us right away. Again, to contact me, to contact my team so we can actually have that discussion, employmentlawyer.ca. You see that address right there, employmentlawyer.ca. All right, so let's have that discussion. Now for Stephen and for everyone else, if you want to find out how much severance you're owed, we talk about severance a lot. Well, how much is severance? Do I get a week, a month, 24 months? Here's what you do. Here's how you can find out right now how much severance you're owed. We created a tool called the Severance Calculator. All you do to get there is go to pocketemploymentlawyer.ca. You see that address right there, pocketemploymentlawyer.ca. One of the tools there is that Severance Calculator. You click on it, and then you can find out in seconds how much severance you're owed. It's completely free. It's completely anonymous. You don't have to put in a name, a phone number, a company name, an address, nothing. It's just there for your benefit. You answer how old you are, the type of job, and the length of your employment, and it's going to tell you how much severance you are owed. And if you think, well, I'm not going to bother using it, I know how much severance I'm owed, I'm going to challenge you here. I bet you're wrong. Don't believe me? Go to pocketemploymentlawyer.ca and find out how much severance you're really owed. So many people, most people, believe that they're owed. And in fact, they're sure that they're owed a lot less than what they're actually owed. So take that challenge. Go to pocketemploymentlawyer.ca. Use our severance calculator. And if you want to, you can also, there's a button there, if you want to only, to contact me directly from there. Okay? So pocketemploymentlawyer.ca, our severance calculator tool there. It's the first place you go to if you lost your job, if you're about to lose your job, or you're even worried about losing your job. So check it out, pocketemploymentlawyer.ca. Next question from Claudette. By the way, guys, still about 10 minutes to go. Ask your question. Lior Samfiru, that's me, the employment lawyer, answering your questions. Claudette on YouTube. Should employee contracts be reviewed prior to signing, or is it dependent on a certain level? Every employment agreement should be reviewed. Now, listen, if you're a 16-year-old and taking a part-time job at a fast food restaurant, no, don't bother. But if it's not a part-time student job, if it's an actual job, a career job, you need absolutely always to have it reviewed. And I did talk about this a bit earlier. There's a lot of potential terms that can be problematic and cost you tens of thousands of dollars. And guess what? They can be easily negotiated. So let's have a chat. Let's have your employment agreement reviewed so you don't find out later when it's too late. Holy crap, I signed this employment agreement and then that cost me $50,000 in severance because I agreed to limit my severance. Or I signed an agreement that allowed the company to reduce my pay or to demote me. Don't find out when it's too late. You have to understand what you're signing before you're signing. Whether you're a new employee or an existing employee, if you're asked to sign an employment agreement, let's have it reviewed. No exceptions. Okay, next question from Jordan. Okay, no, I think we've answered that. Next question from Bill. I don't know what you're talking about, Bill, so let's continue. Steph, how long normally an employment contracts last? If mine was issued in 2015, would there be anything that would expire? So the contract could stop being in effect if your job has changed significantly. So what I mean by that is, let's say you were hired as the marketing coordinator in 2015, and you've been promoted several times. Now you're the director of marketing. Well, then that marketing coordinator contract doesn't apply because you're in such a very, very different position right now, which means now you're employed under an oral arrangement, which is much, much better than having a written employment agreement. It's better for the employee. So that's when it could stop expiring. But that said, the agreement itself could say that it's going to continue to apply regardless of what position you have. If your employment agreement says that it's going to apply forever as long as you work for the company. So we need to see what it says. But generally speaking, if your job changes significantly, I'm not talking about a little change, a significant change, then that contract is not in effect anymore. And that is actually a very good thing if that's what happens. Okay, so Steph, hopefully that helps explain that situation. By the way, to connect with me, off-air employmentlawyer.ca. Claudette asks, do you also review terms of stock options? I do, but generally speaking, there's not much that you can do about that. You're not going to be able to change those terms. You're not going to be able to negotiate those. Where you can absolutely negotiate an employment agreement with stock options, it says what it says, and you're not going to be able to do much about it. But if you have questions, always you can connect and we can answer those questions. So I have a few more minutes here, and I think I've caught up with questions. But you have some time. Ask those questions right now. Take advantage. Don't shut off your computer when it's too late and realize, gosh, I wish I would have asked Lior another question. For those joining us, again, I'm employment lawyer. I'm with employmentlawyer.ca. I'm Lior Samfiru, one of the partners of Samfiru Tumarkin LLP. And I wanted to touch base briefly while we wait for the next question on, again, vaccination mandates. So right now, obviously, most mandates that governments have gone away. In most industries, governments have said, yeah, no, we're not going to impose vaccine mandates. And in fact, we see vaccine mandates being removed for restaurants and gyms and movie theaters, etc. So if now your employer comes to you, and this is still happening, saying, well, no, if you're not getting vaccinated, then you're out of here, then your case, if you will, is that much stronger. Because the government is now saying, yeah, we don't really need people to be, we're not requiring people to be vaccinated. So if your employer is imposing that obligation, clearly that's not something that they have to do. So if they choose to do that and they let you go or suspend you because you're not vaccinated, you're going to be entitled to severance. Okay. So if you are now even, and I've spoken with people earlier today that have now been let go or suspended because they're not vaccinated, as good as the cases you would have had before, now you have an even better case, okay? So you want to reach out to me as soon as possible. See the address right there, employmentlawyer.ca. Bill, I have no idea what you're talking about, but if you commented on the video, that's great. Stephen asks, do you manage intellectual property rights issues? No, we deal with employment law issues. So if you have an employment law issue, we're the people to talk to. If you need a referral to an intellectual property lawyer, happy to provide that referral. Just connect with me. I have some really good friends that deal with that issue, and they'll be happy to connect with you and help you. Steph asks on YouTube, has a follow-up on the expiration of a contract. If it's the same job but added additional locations to your scope of coverage, would that typically qualify as you mentioned? Not likely, no. If the scope of the job is expanded, it's not a significant enough of a change that would render that employment agreement as ineffective. Okay, so you would really have to be in a different role and not a bit different. For example, if you were hired as the marketing coordinator for Ontario, and then you were promoted to marketing coordinator for Ontario and BC, that's probably not going to be enough. But if you were promoted to director of marketing, again, no problem. That's a very different position, and that means that employment agreement likely doesn't apply. Next question from Claudette on YouTube. With many companies beginning to return to work and reopen the offices, okay, what are the mandates to return to the office if the original contract was in the office? That's a great question. One of the most common questions that I've been getting. So Claudette, if your job pre-COVID was to be in the office, your employer is able to require you to come back to the office now. And if you refuse, even though you say, I don't really want to, etc., then that could be a resignation. Okay, and that could be, you could lose your job without any compensation because of that. Now, keep in mind that your employer still has to take measures to make sure you're safe in the workplace. The other thing is this. Your employer may say, come back to the office, and you may say, well, I need some time to make arrangements. I have childcare arrangements I need to figure out, other family responsibilities. So that may mean your employer has to give you some time. They can't say, come back to work tomorrow. So they have to accommodate you by giving you some time to make other family arrangements. Now, if there's a medical reason as to why you cannot work in the office, then you can provide a doctor's note. And again, your employer usually would have to accommodate you. But in other situations, if you were working in the office pre-COVID and your employer says to you, well, now you're going back to the way things were, you're going to be back in the office 5 days a week, they can do that in most cases. And if you don't do it, there could be repercussions. Okay, so hopefully that helps. Let's see. So yes, Claudette, I just answered that. So I'll take another question if there is one. Otherwise, I will summarize what we've talked about today. Employment agreements, you really want to have them reviewed. You don't want to sign them. Severance, a lot more than you realize, okay? It's not a week per year. It could be months. It could be as much as 24 months. Think about it, 24 months, 2 years of pay. That could be your pension, your benefits, your bonuses, your car allowance, your salary, everything. Okay, so you have to get that advice if you lose your job or worried about losing your job. We talked about vaccine mandates. In most situations, if there's no government requirement that you be vaccinated, there's no obligation on your employer by the government to have you vaccinated. If you choose not to be vaccinated, but your employer lets you go because of that or suspends you, you are entitled to compensation. So let's have a chat. Let's have that conversation. You can reach me through employmentlawyer.ca. That's the time that we have for today. So thank you very much for joining us. Again, I'm Lior Samfiru. I'm the employment lawyer. I'm here always answering your questions, but don't wait until the next time I'm back. If you have a question, an issue, a problem, let's connect now, okay? Right after we're done here, you go to employmentlawyer.ca, you reach out, and don't wait that week. It makes no sense to wait till next time. Let's connect now. Guys, thank you so much for joining me. Thank you for the amazing questions. Love those questions. If you want to connect, employmentlawyer.ca. Otherwise, I'll see you next time. Have a great day and a great rest of your week. All the best.